on. Don't be telling me what to do before I even start. Okay. Good evening, ladies and gentlemen. This is the May 18th meeting of Planning and Zoning. Would you please stand for the pledge? I pledge allegiance to the flag of the United States of America. The Republic stands one nation under God, indivisible. Can the clerk please read the roll, please?
Chairwoman Spidell.
Yes, ma'am.
Vice Chairman Richardson.
Here.
Secretary Grant.
Here.
Member Perez.
Here.
Member Rice.
Here.
Member Aton.
Here.
Member Riley.
Here.
Alternate Member Faison.
Here.
Alternate Member Childs.
Staff, council, we have an obligation immediately. Would you like to take care of that and swear in a new member?
Be happy to swear in Ms. Gilbert at this time. Ms. Lisa Gilbert is the school board appointee as your non-voting school board member.
Ms. Gilbert, could you come to the podium, please?
Raise your right hand. I do solemnly swear.
Do solemnly swear.
Support, protect, and defend
Protect, and
the Constitution and government
Constitution and
of the United States and the
States,
state of Florida
State of Florida,
against all enemies,
against all enemies,
domestic and foreign,
domestic and foreign.
that I will bear true faith,
I will bear true faith,
loyalty, and allegiance
loyalty, and allegiance
to the same,
to the same.
that I am entitled to hold office
That I am entitled to
under the Constitution,
under the.
that I will faithfully perform
That I will faithfully perform
all duties
all duties
of a member of the Planning and Zoning Commission
Planning and Zoning Commission
of the City of Titusville,
of the City of Titusville.
on which I am about to enter.
I am about to enter.
So help me God.
So help me God.
Ms. Gilbert, thank you so much for joining us. And staff, do we direct Ms. Gilbert to right beside? Yes.
Yes.
Could you take a chair over there, please? And we'll have a brass plaque for you any minute, okay? Thank you so much. Council, have you informed Ms. Gilbert of what part of the meeting she'll be participating in? Does she have all rights of voting as a regular member? Have you done that, sir?
What I explained to Ms. Gilbert is that she is a non-voting member of Planning and Zoning appointed by the school board. She will not make motions and will not vote, but she can engage in the conversation.
And she can ask questions, is that correct?
Yes.
Okay, do you understand that, Ms. Gilbert? We're throwing too much at you at once.
I have explained that to Ms. Gilbert previously.
Okay, so
we did meet.
you can't vote, but you can certainly participate in discussions and you can certainly ask questions. Okay? Okay, thank you so much. Now, Mr. Faison, would you explain the technology in front of her?
Yes, I will throughout today's meeting.
Okay.
Things pop up such as the star.
Oh, no, we're not talking about the star. No, skip that part.
All right.
Thank you so much. Appreciate it. Next item on the agenda, are the minutes of the May 4th meeting, please. Mr. Richardson.
I move to approve the minutes of the meeting of Wednesday, May the 4th, 2022. Second.
Mr. Alto, thank you for a second. Roll call. No, we don't need a roll call vote. Approved, say aye.
Aye.
Not approved, nay. It passes unanimously. We move on to item number 9A, the ordinance for billboards abetting I-95. Staff, please.
Chair, I believe you have a member who wants to address this issue before we.
Mr. Rice.
Yeah, just on the record, I think you have in front of you a handout that I filled about Form 8B, which is a conflict of interest form. The reason I have a conflict of interest is although this ordinance is not site-specific, it does affect a site that I'm currently have contract under. And I was actually the person that went to city council and requested this ordinance change. It was basically because I had a 3-acre site that was slated to be a hotel, and we found an ordinance in the city of Titusville that said that you could not have a billboard could only be the only use on a piece of property. So either could be the hotel or the billboard. And since the billboard had a long-term contract, it basically either we change the code or the project is dead. So that's my conflict. I declared, I discussed it with legal, and that's pretty much all I'm going to say tonight on the subject.
Thank you. Would you feel more comfortable speaking from,
I'm done speaking. That's it.
you're finished speaking?
Yes, I
Thank
will
you
say
very,
nothing
very
else.
much.
And could I confirm with the clerk that she has received a copy of Form 8B filed by Member Rice, and has copies been provided to the members?
Yes.
Thank you, counsel. Staff, please.
Oh, I'm sorry. Since Mr. Rice will abstain, you can appoint an alternate to vote in his place, if an alternate is here tonight.
We have one. Thank you. Staff, please.
Thank you, Chairwoman, and good evening, Commissioners. This item begins on page 7 of 33 on your agenda packet for tonight. On January 25th, 2022, City Council received a request from a citizen to consider amending the billboard regulations for properties abutting I-95. Section 32-2 defines a billboard as a freestanding sign erected and maintained by an advertising business or service. A more precise description found in Section 32-26 is more useful in differentiating a billboard from other freestanding signs. Section 32-26 states that billboards shall have a maximum height of 35 feet and shall be at least 10 feet above the ground. In addition, the maximum allowable sign surface area of 400 square feet is significantly larger than other signs. On March 8th, 2022, City Council provided consensus on advisability to amend the code requirements for billboards. The proposed ordinance makes the following changes to the code. 1. Billboard signs may be permitted on properties adjoining I-95 right-of-way and that share a common property line with the right-of-way for a distance of 200 feet, and the ordinance eliminates the need for a minimum frontage of 200 feet from an existing paved right-of-way. 2. Billboard signs are not required to be the only use of the lot or parcel if the property adjoins I-95 right-of-way. A map depicting the location of existing billboards along state highways is attached. That's on page 9 of your agenda. And I wanted to point out 2 specific details about the map on page 9. The first is that this map only shows billboards on properties that are within the city limits. And so there may be additional billboards that you see around town, but those are in the unincorporated Brevard County. And second, that this ordinance is specific to billboards along 95. And so while the map shows additional billboards along State Road 50 and I believe State Road 406, this ordinance only impacts billboards along Interstate 95. Additionally, I wanted to point out on page 11, the language in subsection 3B is specifically drafted not to use the word frontage, and that's because frontage can be implied that there's access, and we understand that Interstate 95 is a limited access highway, and there's virtually very little chance that a property will be granted access onto 95 just because it's adjoining to 95. And so the language used there is a sharing a common boundary. There isn't a revised version showing this change in your agenda star. I did print it out for you just in case the agenda star gives you some issues.
Most appreciated.
And so the change in this draft that I've just handed out is on page 3 of 7 and is highlighted. It's also on page 2 of 7. The language is broken out so that it's no longer under the heading minimum frontage. To clarify that the shared property boundary is not necessarily a frontage, but is a, how do I clarify this? So we didn't want to confuse anybody by putting in the version that's in your agenda packet tonight, that language about a shared common property boundary is under the heading of a frontage. And so to make it clear, it's been broken out from the section called frontage and is specifically called Billboard adjoining I-95. That's subsection 4 on page 2 of 7 of the handout. And that's the end of my presentation. I'd be glad to answer any questions.
Clerk, are there any cards on this item?
Do you have a card for this item? Okay. No.
Commissioners, what questions do you have on this item? What clarifications do you need? Mr. Anton?
Do we know why it was drafted the way it was drafted originally, where it was the sole use?
I don't.
Mr. Faison?
Historical data or other municipalities, do they use that same language, meaning sole use of a parcel for a billboard?
To be honest, I don't know.
Further questions or comments? Ms. Riley?
Why did they have in the ordinance before that you could only have either the sign or the business?
So I think that goes back to Member Aton's question of where this originated from, and I don't have a clear understanding of why that limitation was established.
Additional questions, Ms. Riley?
The 200-foot property line, is that a new thing? In fact, they have to have a 200-foot property line adjacent to the right-of-way on I-95 to have a billboard. Is that new?
So if you'll see on page 2 of 7 of the handout, the number 200 is existing language in the code under subsection 3A. It says a
Did
minimum.
you say 207?
2 of 7.
Yeah, I'm sorry.
Handout is just numbered 1 through 7.
Right, so page number 2 of 7.
Oh, okay.
Sorry.
Or you can go to the star.
And so the language is existing language in subsection 3A at the bottom, near the bottom of the page. It says a minimum frontage from existing paved right-of-way of 200 feet shall be required. And so this would exempt properties along 95 from having frontage, but they would have to have a 200-foot length of shared boundary with the Interstate 95 right-of-way. So again, the point was, let's not use the word frontage because that could imply that they have to have access onto I-95, where access onto I-95 is very limited and unlikely to be approved. That distance is being carried over, though, that same 200 feet from what's existing in the code to apply to the properties on I-95.
Any additional questions, Ms. Riley?
I guess I just don't understand that, and maybe I'm a little dense with.
Clarification?
So the distance requirement, I believe, is
Because
just,
on one hand, you're saying you have to have 200 feet go along the right-of-way. And then you're saying, but then for I-95, you don't have to do that?
right. So on I-95, it's the same concept. You have to have share a portion of the property with I-95, but that doesn't establish the frontage. The frontage is still, the city wouldn't approve development on a property that doesn't have frontage onto a street. And so, since these are specific to billboards and I-95, it's not expected that these properties will have access or frontage onto I-95. It's just another word for frontage, making clear that there's no requirement that they have access.
So they could be like a 10-foot section of, onto, close to the right-of-way, next to the right-of-way, and just a lot of land on the other side?
Right.
Is this a cleanup job, Eddie?
I don't know that this is necessarily a cleanup job because it does change some things as far as currently the code does not allow you to use a property for anything more than just a billboard. And so this would allow for more than just a billboard to be approved on a property. I think council's direction was to draft this ordinance with the idea that a billboard should not take an entire parcel off the table for development, that if it can fit, that the property should still be allowed to be developed upon.
So can we assume that this property is thinking about being developed?
I would say that this ordinance is not being drafted for a specific property. I know of at least 2 properties that this ordinance may impact.
And do you know how far they are in the development?
The development process,
Correct.
we have not received applications for these developments.
But it's a possibility.
Correct.
Okay. Would that come before this body? Would the development, any phase of the development come before this body?
Variances go to Board of Adjustment and Appeals. I don't foresee it coming before this body.
And how, Mr. Perez?
I was going to ask, Eddie, you said that there are 2 other properties. How big are those properties?
Just a second. But again, I do want the commission, I will look that information up, but I do want to remind the commission that this is a policy-based decision that will apply to all properties. And so even if we're only thinking about the 2 that I have on my mind, there may be additional properties within the city that this could impact. The first property is 3 acres and the second property is 25 acres.
Member Grant?
I'm just, sorry, go ahead, finish. Sure.
A follow-up. So is there, since right now, these 2 issues are mutually exclusive, either one or the other, was there any kind of bearing on the size of the property as to whether or not, one would impinge on the other as far as developing it and having this billboard there, or do you have any idea?
So no, right now the code is written where if there's a billboard, that is the only use that's permitted. It's not to say that if a property is greater than 5 acres, that it may have a billboard.
Member Grant?
I'm still trying to understand this. Can we use Lowe's as an example? You know where Lowe's is, right? And it's not, see, it does not, you don't have access from 95 to Lowe's. You have to go down Cheney. So, would this allow Lowe's to expand their property line further line towards 95? Is that what you're saying here? I'm not quite sure. I'm lost, man.
Okay, let me try to clarify. So
Please do.
I'm looking at the Lowe's property. I wish I could pull up the map for you, but just using the measure tool on the property appraiser's website,
Huh?
the Lowe's property has 1,320 feet of a shared property boundary with I-95 already.
Okay.
So, but their frontage is along Serpentine Road on 50.
50,
or
right.
on South Street.
Oh, yeah, okay, you're right.
So what the ordinance is trying to do is say that the billboard has to touch 95 for it to classify it for this new section, for the billboards on I-95 section. If we didn't have that in the code, then this could possibly apply to other billboards throughout the city, not just properties that are adjacent to I-95. And then, again, the reason why we don't use the word, they must have frontage along 95 is because we don't want to imply that it has to have access.
Member Riley?
I just thought of something that might be the reason why they had the rule that you couldn't have a sign in a building on the same property. Would that be avoiding the sign law? Isn't there a sign law that regulates how big a sign can be for a business?
There is a section of the land development regulations that touches on sign size.
So hypothetically, could somebody violate that ordinance by, in fact, having a billboard on their property with their building? Buy your groceries here, or whatever it was.
That's a good thought. That could be it. And I will just add that the Supreme Court has ruled that cities cannot regulate the content of the signage. And so we could not approve an ordinance that would say that you can't use the billboard for, let's say if there was a hotel at the site and it had a billboard, we couldn't write an ordinance that said that on your billboard you can't advertise for that hotel because we can't regulate the content of the
But
advertising.
all you can do is regulate the thing that's sitting on the
Right,
property.
size, location.
I don't know. I mean, I'm just trying to think why they would.
It was my understanding, and say I'm wrong, that when the properties on the west side of I-95 were in the building stage, that they did indeed have signs mounted on their buildings advertising their property, advertising the name of their property.
Are you talking about wall signs? So signs that are attached to the wall of the
That are
building?
attached to the walls of the building. Okay.
So the sign code treats those separately from billboards. So they
Okay.
would still be permitted to have wall signage.
Okay. Is that what you were talking about, Ms. Riley?
Violate the sign law, but have, huge sign.
Thank you. Mr. Faison, please.
When talking about the parcel, so in this particular case, the 3 acres and then the 25 acres. So for there to be a sign on that parcel, it's the totality of the parcel, correct? So all 25 acres in one case could not be used because the sign is there.
Correct.
What about allowing subdividing that parcel to allow a sign? Why is that not an option? So for example, 25 acres, take a half of an acre, for example, designate that just for the sign, and then the sign goes there. Why is that not an option?
I don't know that it's not an option. I will say that there's also a minimum lot size. So that's on page 2 of 7 of the handout. Subsection 2A says a minimum lot size of 1 acre shall be required for billboards, and that shall not be subject to a variance.
Would one way of fixing this just be reducing the lot size? Say from 1 acre to a half acre? Would that be sufficient for a sign? For a billboard?
Possibly, that could be a recommendation.
Member Elton.
So are is there some grandfathered in signs, I guess? So since Lowe's came up, it appears there is a billboard on the Lowe's property, which building on it. And then the property to the north appears to have 2 billboards, which is also against, or it's a huge piece of property, or per property. Those grandfathered in?
My understanding is that they're non-conforming signs at this point.
Well, there's
But to
none.
go real quick, just to go back to Member Fason's comment about the smaller lot size, that still doesn't address the frontage question of, do they have the 200 feet frontage on 95 and do they have access onto a paved roadway?
Well, So as the sign sits today, so let's say some of these signs, right? So are we looking at erecting new signs or are the billboards already there?
The ordinance would apply to new signs.
Okay. And is that 200-foot requirement now being added to it, or is it already there? Because I believe that's already there, correct?
Correct. There's existing language in the code that says a minimum frontage of 200 feet shall be required.
Member Faison, any additional comments or questions?
No, I'm good. Thank you.
So those properties that are out of compliance at this point, this ordinance would not affect. Would then code enforcement be applied to those properties that are out of compliance
No, ma'am. So non-conforming signs generally are allowed to continue as they exist.
as a grandfathered in situation? Okay, thank you. Additional questions from staff members and commissioners, please. Seeing none, call for the ordinance. Member Richardson.
I make a motion that we recommend approval of this ordinance, 9A, Billboards abutting I-95.
Do I have a second?
Second.
Clerk, may I have a roll call vote, please?
Member Riley?
You have to vote unless there's a conflict.
Vice Chairman Richardson?
Yes.
Member Perez?
Yes.
Member Aton?
Yes.
Secretary Grant?
Yes.
Member Faison?
Yes.
Chairwoman Spidel?
Yes. Does member clerk, council, does member Riley need to state the reason for her vote?
Not a legal requirement to do so, but she
We've been-
certainly could state why if
We've
she
been
thinks I
doing-
would assist council.
We've been doing that only so council then knows. That's been our kind of standard procedure. Member Riley, you want to comment or? You don't have to. Okay, thank you so much. Member Richardson?
No.
Nope. Thank you. Moving on to item 9B, adult daycare ordinance. Staff, please.
Thank you. This item begins on page 16 of 33 of tonight's agenda packet. Recently, the staff has received a number of inquiries regarding adult daycare centers, which are not currently a permitted use in the zoning code. Based on a request from a citizen, City Council approved advisability for staff to develop an ordinance to permit adult daycare facilities. The proposed ordinance establishes adult daycare facilities as a limited use in the neighborhood commercial, community commercial, regional commercial, office professional, downtown mixed use, regional mixed use, urban village, Indian River City neighborhood commercial zoning districts with the following standards. A, shall be required to proceed through the conditional use permit process when located on a local street or abutting property with a single-family zoning or use. B, shall provide a landscape buffer in accordance with Chapter 31, Article 3, Division 10 on non-street property lines. Properties in the DMU zoning district shall provide landscaping pursuant to Chapter 31, Article 3, Division 10. C, shall set back all structures, playgrounds, and outdoor recreation areas a minimum of 50 feet from any abutting residential zoning district or residential use, except mixed residential commercial uses. D, shall provide a passenger drop-off zone adjacent to the facility, providing clear ingress and egress from parking and other areas. In addition to the requirements above, adult daycare facilities in the urban mixed-use zoning district shall be located on property that is adjoining to an intersection of De Leon Avenue or Park Avenue. Just a quick summary of the ordinance. So this was modeled after the child care ordinance, the child care facilities section of the code. It's intended for adults who need supervision. So that could be teenagers with developmental disabilities who have aged out of typical care, or older adults and seniors. I think that's all I have on my summary sheet. So with that, if there's any questions, I'd be
Clerk, are there any cards on this item?
Do you have a card on this item?
Could you come to the podium? State your name and your address, please.
Hello, my name's Laquita Collins, 5110 Volusia Avenue.
Thank you, Ms. Collins. Can you present your proposal?
Oh, yes. So with the adult daycares, there are not many within the city limits of Titusville. I had the pleasure of working with the BLAST program at Titusville High, and I saw that there was a need for day programs for students that age out of the BLAST program. Yeah.
Can you talk to all the commissioners about what age means age out of a program and what's your current population? Because I know you have a lot of students right now that we're going to lose.
Yes, at the age of 22, due to certain laws and guidelines, students who have deferred their diploma are aged out of the BLAST program. So if their family does not have any type of respite care or anything like that, the kids are, I don't want to say kids, the young adults are left at home, you know.
Could you share with the commission some of the things that BLAST does with these
Yes,
students?
define BLAST.
Oh, okay. So BLAST, it helps students with special needs. It promotes independence. And depending on the student's cognitive function, if they're able to live independently, we'll prepare them for that. We just try to work on social skills and we use different recreational activities just to promote independence and dignity.
There's a certain amount of activities at Titusville through the BLAST program that these students have participated in. Have you been with the program long enough to describe those?
Not that long, but some of them, I know one of the programs is called, can't think. I'm so sorry.
That's
But,
okay. Just describe some of the things that these students have learned.
It's like a vocational program. So like I mentioned before, the students that have the cognitive ability to go out and find jobs, we partner with Publix, Cape Canaveral Hospital. We've had a lot of students get a job after they have aged out with Publix, Cape Canaveral Hospital. One student just got a job at Durango's not too long ago. So it's pretty successful.
So you do teach a certain amount of work-related skills.
Yes, ma'am. Yes, ma'am.
Before the COVID, do you remember what program was presented at the courthouse on 405? Were you with the program at that point?
No, ma'am.
Am I allowed to describe this program? This was a coffee shop.
The coffee cart.
Yes,
Sorry.
the coffee shop. Very, very successful. Okay?
Yes, ma'am.
So were you with the program then?
Yes, ma'am.
Okay. Describe that because the commissioners really need to know about that.
That's how we raised a lot of our money. We don't receive any funding from the school board, so on a daily basis, we would go to the coffee cart. We would sell coffee, of course, snacks, sodas, and that's how we would raise our money to provide lunch and do certain outings in the community.
Thank you. Describe what happens when a child ages out or a young adult ages out at 22. What happens then? Where could they go?
They
can be picked up by certain employees, but what happens to those that really kind of need what you're talking about?
They're at home, and who's to say, you know, what type of living situation they have? You know, a lot of students tend to excel and do better in the BLAST program, but when they're aged out, if the family doesn't have, you know, the ability to put them in a day program, it just tend to.
who's going to be running this program, supervising this program? Are you going to?
Yes, ma'am. Myself.
Okay, and are you going to depend on federal grants or local grants or?
That was the plan. I didn't want to charge the families. I was going to depend on private pay and different grants.
Is there transportation
Yes.
going to be provided?
Yes, ma'am.
And who's going to fund the transportation?
Myself.
What about the liability of the program? Are all those things being investigated now?
Yes, ma'am.
I do not want to I know about this program and I know what you do, and thank you for doing what you do. Member Grant, do you have questions?
Actually, I had a couple of questions, one for staff, and now I have one for you. I apologize, but I was under the impression that this was for more elderly folks. When you said adult daycare, there was nothing specific in the write-up here that said you would be dealing with what age?
18.
18?
Yes, sir. I
I apologize. I was thinking we were talking about, I was thinking that you were talking about folks who are elderly and they're at home, their children taking care of them, and of course the children have to work and you can't leave them at home by themselves. So I thought that's what this was about, because it wasn't specific to tell me otherwise.
yes.
Chairwoman, could I interrupt real quick?
Yes, please. You're next.
I want to clarify that this, again, is another policy decision, and so this ordinance isn't specific to this organization. Once we create this use, other applicants can apply under the same use, and they may be more tailored to senior citizens.
Because I did some research on it, and that's what came up. And I said, oh, cool.
Well,
Great.
it's still relevant information to the discussion because that is part of it, but the program that's being described by the member of the public at this point is a little different than what you had researched. But both of those types of programs apply under this definition.
You have something to say, ma'am?
Oh, yes, sir. I do plan to, after I get this up and going, to open up a program for senior citizens. But this is my passion. Last is my passion first.
Staff, could you elaborate a little bit on D, the last sentence, please?
Yeah, definitely.
The last sentence of D,
Please.
is that under subsection C1
Where is it?
on page 24 of 33?
Front page, man, in the summary and explanation.
16 of 33.
16.
Yeah, page 16, excuse me, sorry. D, last paragraph, last sentence.
Yeah.
Could you just elaborate a little bit on that, because I'm not sure what that means.
Okay, so that's similar, that's the language that came from the child care facilities. It's just language that's been carried over that's existing in the code specific to child care facilities. We thought that this use is very similar to that. And so what that's requiring is that if there are a large number of clients who need to be dropped off or picked up at one time, we want to make sure that that doesn't cause issues for the surrounding properties with traffic. And so it's to show circulation, it's to show enough stacking, things of that nature to make sure that it's not causing an issue with the number of vehicles arriving at the site or departing from the site at the same time.
So that's why De Leon and Park Avenue was mentioned in this.
Oh, I'm sorry.
That doesn't make any sense.
Sorry, so is that not subsection D, shall provide a passenger drop-off?
No,
That's the first
last
part of
sentence,
it.
The last
Last
sentence.
sentence.
Paragraph.
So, next subject. That line is existing language in the code under the zoning district. The urban mixed-use zoning district has that requirement currently, and so it's to make sure that we are referring to the urban mixed-use standard. The urban mixed-use zoning district requires that these uses be along De Leon Avenue or Park Avenue.
Really?
Member Richardson, please.
Something new every day.
I'm through with the applicant. If my questions are strictly for staff.
Okay. Do you want to ask him now?
Yeah.
Okay.
Is there any kind of limitation? Say, person has their CNA license, a certified nursing assistant. she wants to have a couple of individuals she provides daycare for in the house, in her house. Is that legal under this?
So the,
A residential zoning district?
this ordinance is not written to allow this use in residential zoning districts. I don't know that the license of the nurse has any bearing on whether the operation is licensed by the state. So I do want to address why residential was not recommended for this use. And I will say that the legal advertising for this ordinance was written flexible enough that if the commission would like to propose that it also be allowed in the residential districts, that I believe that could be done tonight. But the requests that the city council has been receiving have been for properties that are in commercial zoning districts. And so this is an opportunity to allow it in a commercial district and see if there are any unintended nuisances to the neighboring properties that, if not later, this ordinance could be expanded to residential districts. But I did want to point out that these facilities are not licensed by the state, and so there is less of an oversight. And so those were some of the considerations in whether or not to recommend this be approved in residential zoning.
I see the attorney's chomping at the bit.
In reference to your question, there was recent legislation last year with home-based businesses where we have to allow home-based business. So if you're referencing is maybe a CNA who owns a home and wants to have a couple, as long as they meet those requirements, you could potentially have that in a residential under a home-based business.
Okay. That solves a lot of my problems with this.
Thank you, counsel.
Because my dad is 92, my mom's 87, and they require some assistance occasionally. It'd be nice if there was a way she could drop off my dad at a adult facility where he could talk to people the same age while she runs errands or she has some spare time to do things. And I'm really concerned that we allow that in residential districts. A limit of 3. And as long as this proposed ordinance does not make that illegal, I'm for it. If what the attorney said, they can develop a home-based business based on that, I'm satisfied with that.
Member Rice, please.
Yeah, a couple questions I have for the applicant and then some for the staff. First, what's your hours of operation?
8 to 5.
8 to 5? 5 days a week, 7 days a week?
Yes, sir. Monday through Friday.
Okay. 8 to 5. Okay. And then do you have any medical people on staff, or do you prescribe medication, or do you just, should they take medication? Do you do any of those things with medications?
I'm sorry, depending on the severity of the client, but we will have a nurse on staff, and our direct care staff will be certified as either a CNA or they would have a background working in a group home setting.
But you don't prescribe any medication?
No, sir.
You just make sure that
Yes.
they take it? Okay, great. I think that helps me a lot.
Member Faison, please.
And then I have some
Oh, I'm
questions
sorry.
for staff.
I'm
okay?
sorry.
Under definitions, okay, the last sentence says participants may utilize a variety of services offered during any part of the day, but less than 24-hour period. So a savvy business owner could shut down at 11:59. So you shut down for 1 minute is 23 hours and 59 minutes is less than 24 hours, and then open right back up. What's the intent of the hourly thing?
Sure. So the intent is to limit overnight care, overnight stay. And so if that language needs to be replaced with no overnight care, that's an option, or leave it at 24 and hope that no one gets crafty like that.
So I'd have a tendency to say from 5 in the morning to, 8 at night, which is a pretty, people could take and drop people off before work and then pick them up after work. It sounds reasonable to me, but, a savvy person could technically be within the law by shutting down for 1 minute every day. If that's, what are we trying to protect here? And so that was that question. The other is, I noticed, and I did compare it to the child care facility, okay? And like Member Richards said, child care facilities are allowed in residential. Okay, it's a conditional use though, okay, but they're allowed. And why the differentiation between adult care and child care with the use and where the location is? Why do you have that definition, that differentiation?
Sure. Again, so the idea there is that this use is not regulated by the state, and so it lacks an additional level of oversight. But the request that the city council has been receiving about this use has been for properties that are commercially zoned. And so this gives the city a chance to allow the use in the commercial districts where it's being requested and see if there are additional unintended impacts, nuisances that the use causes that the city may need to review more carefully when allowing it in residential districts.
Well, what oversight does the state do that would go away because this is not state regulated? What does the state come out and visit these sites once a year? What do they do under that statute?
What I can tell you is that they're licensed. I don't know about their inspection frequency, but my understanding is that they come out once a year to inspect the facility, but I couldn't tell you that for sure because I don't have that information.
And City Attorney, if I just want to make sure I understood what you said about home-based business. If it wasn't included in these residential, even conditional use, it still could be afforded if they follow the rules of the home-based business, is what I understood you to say. Is that correct?
Right. The point is that there are some businesses that are conducted as home-based businesses. And a lot of cities had regulations on home-based businesses. The state came out with recent legislation, which we've adopted, that you can operate home-based businesses, obviously in residential, but there are certain things as long as you comply with parking. But as long as you are complying with parking and other regulations applicable to other businesses, you can conduct a home-based business in residential. Now, I can't say every single business. There might be some laws that apply to particular activities. But in general, you can conduct a home-based business.
So there's nothing in the home-based business regulation, because I don't have it in front of me, that would prohibit this use as a home-based business.
I haven't researched that, but I don't.
As long as they comply with home, as long as you live
Right.
there and
I
a
knew
certain number of
specific
employees,
requirements.
there's criteria that comes with that. That's correct.
Member Faison, please.
How you doing?
I'm good. How are you?
Good. You nervous?
Yes.
I can tell. I've been there myself. So I got a couple of questions for you. First question is, how many students do you think you'll have at any one time?
Hoping to grow, but I'd say 8 to 10.
8 to 10. Okay. Now, right now, you're on a platform that is being streamed. It's being recorded, and this will be on YouTube. Okay. And there are many people that actually watch this later on. And so, Mr. Spidey, I'll ask you a lot of questions to help you get your information out there in front of people. So if I was somebody who needed your services, or if you had the chance to talk to the world about what you're trying to do, what would you tell them?
It's definitely a need here in the North Brevard area.
No, tell me about you, your company, and what you offer. Tell me about your business.
Okay, so it'll be a day program for people with special needs. It'll be Monday through Friday, 8 to 5. We'll assist with, activities of daily living, so personal hygiene, depending on the cognitive function, will help the help the individual with daily household tasks like doing laundry, money management, preparing simple meals and snacks. We'll have different recreational activities available, and this would provide respite service for the families and caregivers.
Awesome. I appreciate that. All right, now for staff, Over by the Brevard County Sheriff's Department, there used to be a facility called Joe's something or another.
Joe's Club.
Joe's Club. What zoning were they under?
I can look that up.
Because if I'm not mistaken, Joe's Club is an adult daycare facility.
I believe it's hospital medical, but so if it's 830 South Park Avenue, just south of the sheriff's facility, then it's zoned hospital medical.
Will your facility be out of your home or out of a building?
Out of a building.
Member Riley?
Mr. Galindo, are there other urban mixed-use zoning in Titusville besides Park Avenue and De Leon?
Yes, so the urban mixed-use district generally is north of Pine Street, south of Orange, near Blanton Park, east of Blanton Park to the railroad tracks where DMU picks up. And so it's quite a significant area. It's not just along the road right away.
So do you have any idea why there is that, you said that this pre-existed, the fact that they had to locate the adult daycare facilities on an intersection from De Leon or Park?
Yes, ma'am.
Do you have any idea why that was?
I don't have the rationale for that. I did want to pull up the language just so I could help explain. So just as an example, I'm looking at section 28-138, which talks about laundromats. So it's completely irrelevant, but just as an example, the standards for the limitations, while the use is permitted in urban mixed-use zoning district, it says in the urban mixed-use zoning district, laundromats must be located on property that is adjoining to an intersection of De Leon Avenue or Park Avenue.
Laundromats also?
For laundromats. And so the intent of that being in this ordinance is just to carry it forward. However, I don't have the rationale for why that intersection or those streets.
Seems a little odd.
Member Aton?
Couple. So if I wanted to do say this is an example, this is a policy decision, is this available as for CUP process? This would eliminate the process, or there's just no way to do it unless it passes, and it doesn't even see. Go ahead and fine with. I didn't understand CSP process to permitted or whether we're just allowing it to there wasn't a way.
Sure. So the latter in that case, this is a use that's not in our zoning code now. If we were presented with an application, we wouldn't be able to apply any of the existing uses. And so we're creating this use and allowing it with limitations in the certain zoning districts we've recommended.
And then as it relates to the urban mix, I mean, I kind of get Leon Park or big, but based on your description, South Street runs through urban mixed use.
South Street does not.
So
It's a couple blocks north of South Street along Pine Street, or from Pine Street north. So that's 2 blocks north of South Street.
So, so kind of park and urban mix. I don't know.
Sure.
So the idea was on a feeder street, not on a.
Sure, yes.
If we did want to move forward with this and a recommendation that that part be out, does that zoning ordinance, or can we say the second part of D after the in addition to?
I don't believe it'll cause a conflict. I'm going to look at the urban mixed-use zoning district to see if it has specific standards, to see if there's a conflict.
That's all.
Member Richardson, please.
Yes, I'm in general an advocate of this adult daycare ordinance. Because even if it's a home-based business, limited to 2 or 3, at least that gives them some personal enrichment. And it does yours people too, people you're serving. Because the cost now, and cost of everything, the cost of assisted living is getting outrageous. It's as much as $6,000 or $7,000 a month. So I think we'll see more of this happening, whether it's a home-based business or these in commercial zoning districts. I gotta say, I'm getting a little tired of conditional use permits. They're about required for everything nowadays. But I understand what the city is wanting to achieve here. But I would agree with what Commissioner Anton said, that somehow we need to delete adjoining to the intersection of De Leon and Park Avenue. It creates a lot of confusion, exactly.
So to follow up, I didn't see anything that specifically prohibited certain uses along the those two right-of-ways or that at that intersection. So I believe if the commission's inclined to make the recommendation without that limitation, that you could. And then if upon further research we find that that's the case, we'll present that to City Council.
Would you like to add any additional comments?
No, ma'am.
Thank you so much.
Thank you.
Thank you for what you're doing.
I bet Member Faison made you a little bit nervous saying here on YouTube, it's going to be seen by tens of 20 people.
But you can play that back at home and then call your friends too, okay? Seeing I close the public hearing and call for a motion on this agenda item, please. Yes, Member Grant. Oh, Mr. Perez, I'm sorry.
It's all right. It just occurred to me, are there requirements on the ratios of individuals providing care to clients that are in a particular situation such as this?
No.
No.
Doesn't that probably fall under licensing?
If it were a licensed use, yes.
Yeah, I think that might be a licensing situation, but I may be misspoken too.
And Chairwoman, if I could add one more thing, I did forget that I
Thank you.
printed out one more thing that's in your agenda star tonight. Just, it's a very simple change. I know we try not to provide changes after you've already been studying the agenda. I know that's stressful, but this is a relatively minor change, just striking the words in subsection C. It currently reads, shall set back all structures, playgrounds, and outdoor recreation areas, and it's been changed to say, shall set back all active recreation areas. And really the change there is just to not use the word playgrounds. We didn't want to make it sound like seniors would be using playgrounds, and so I do want to pass this out just so you can review it.
Thank you, sir. I'll ask one question. I mean, the ETC covers, lots of different things. Is that sufficient on item C, just to put ETC?
Well, we don't want to make it extremely limiting in case there are other active recreation uses not listed.
It's undefined. Any other commissioners? Last call for questions or comments from a commissioner. Can I call for action, please? Member Richardson.
I didn't even push the button before you
I
always
knew
recognize
that's
me.
body language.
Given that attorney has assured us that it will be allowed under residential zoning as a home-based business, I would make a motion to approve the ordinance as recommended, 9B, with the exception of the last sentence in item D, striking the intersection of De Leon or Park Avenue.
Do I have a second?
Second?
Is that,
Chairwoman, could I ask for clarification? Because when I look at the draft language of the ordinance itself on page 24 of 33, the language that I believe Member Richardson is proposing to strike is noted as subsection C2. And I don't want to get that confused with subsection D above it that talks about the drop-off zones the way that I misunderstood earlier.
do we need to restate that?
No. Amend it as section C2.
Thank you.
Okay.
And Chairman, I'd like to clarify with regard to the home-based business, I cannot guarantee that every person who wants to do some form of adult daycare would qualify as a home-based business or residential. I'm merely saying that there may be the ability to provide that care as a home-based business if you meet the criteria under the home-based business code, whereas previously that wouldn't have been possible. With the new legislation and home-based businesses, it does expand the ability to do that.
We
But there are
appreciate,
certain criteria that do come with home-based businesses under the statute that we can't vary.
we appreciate that clarification. Member Rice,
Yeah, did the motion include the staff recommendation?
we have not received a second
of
on the
1C?
motion yet.
With recreation, making that change? Yeah. Does the motion include the recommended change that staff recommended under C1C, taking out structured playgrounds and outdoor recreation areas? And just,
Yes.
You know, and
because
just saying recreational
it was
areas.
shown to us and implied that it would include that.
Call for a second, please.
Second?
Is that Mr. Perez? Thank you. Roll call vote, please.
Secretary Grant,
Yes.
Member Riley,
Yes.
Vice Chairman Richardson.
Yes.
Member Rice,
Yes.
Member Perez,
Yes.
Member Aton,
Yes.
Chairwoman Spidel.
Yes. Thank you so much for coming. Good luck, and it is a serious need in the North Brevard. We hope to see you again. Invite your friends over. Channel 489, I think, no, 98, 498. Yeah. Thank you so much. I'm going to deviate for the agenda, please, and ask Mr. Richardson for a very important
Could you get
proposal.
Officer Willie in here?
Thank you, OJ.
Don't come up to the podium, stand up there.
There won't be any dancing. Member Richardson,
Officer
please.
Willie has done so much for this community. He will be honored tomorrow night at 7 o'clock on Channel 6 for the Getting Results Award. Everything that he has done. I was happy to be part of the nomination process along with Jolene Nelson, who won the award previously.
Yes.
And all of you have done with Fighting Edge. And I don't think you have any spare time, do you?
No, not really. I get a half a day off on Sunday is what I get off.
After church, right?
Yeah. that's
But
after
if-
service.
If everyone gets a chance
Yeah.
to tune in to Channel 6 at 7 o'clock tomorrow night, that's the formal presentation on tape of the award. And Willie has done a great job.
I thank you guys. Thank you. That Thank you, Mr. Aaron. No, that came to like a true shocker to me because, like, as you all know, you don't do anything you do for this community for recognition. You do it because you have a drive and a passion for the people for this community. And same thing. But when you get recognized, the only thing you really want to talk about is the people that are helping and stuff like that. So the guy is literally, he's asking me questions, and I'm like, I don't really know how to answer that. I say, but let me tell you about this guy right here. You know, he's like, well, no, we really want to hear about you and this program. But it was a true shocker. And Ms. Joe, I really appreciate you and the whole panel just for the recognition of, and I just wish more people got acknowledged like that are doing things.
They're picking good people.
It's rather unique that also the Boys and Girls Club under Councilman Nelson and under the Bridge Ministry.
Yes.
And now Fighting Edge. All three have been recognized on Channel 6 News as
Yes.
getting results.
And that shows you the commitment that we have in this town. The love for the people of this town that we have, which is it's a beautiful thing. So, there's a lot more going on that goes unrecognized and stuff like that. So I just want to say thank you to you all, what you guys do here.
Thank you, Willie.
So,
Thank you, Willie, for being an example for all of us. We really appreciate it. Thank you.
I'll be
Okay,
running
Channel
for
6,
council one
what
day.
time? 6 o'clock tomorrow? 7 o'clock tomorrow, okay. Petitions and requests from the public present. Stan, do you have something this evening? Thank you.
My name is Stan Johnson. I'm a registered professional engineer, registered in 1976, a long time ago. In 1980, I also became a registered surveyor. The license is inactive at this time for surveying. I'm here because I'm very disturbed and I'm losing a good bit of sleep over a matter that involves the city of Titusville, and it also touches upon planning and zoning, which I've sent numerous emails about this. And that is that I discovered a fake survey for a project that is over $10 million, and it's advancing towards construction. It's advancing also toward being sold, what I've been told. So I'm asking, since the city manager will not return my calls or respond to emails, I'm asking P&Z to ask city manager to look into this, because this can be a catastrophic issue. And what I've done is I prepared a nuisance poster. I don't want to say it's nuisance because I know you don't like to see them. But I'm going to show you this poster. So what it has to do with, it says that this is over $10 million. This project, SNJ Oaks, it's come before you back in August of last year as a sketch plat. And at that time, I criticized it because it didn't show Mockingbird Lane, which is shown on street maps and so forth. But it wasn't shown on the survey nor on the site plan. So, but in February, and so when I filed a complaint to the survey board about numerous violations of minimum technical standards, and then in February, I discovered that the survey was fraud. It's fake. It's fake. In other words, nobody could have measured the angle that he says that he's measured. And I've talked to the surveyor about it, and he denies it. But I've got so much evidence from the city to confirm it with beyond any shadow of doubt. It's a fake survey. So this fake survey is is going to be, with this site plan, is going to be sold, is what has been told by the engineer of record to other people. So what's the new owner going to be? It's going to be in a bad situation. So I've sent to you numerous emails about it, and I'm asking you to do something because the new owner is going to be very much damaged. And it's, I don't want to blame our city surveyor because he's not required and he's not allowed to go around reviewing surveys, but it should be looked into.
Thank you, Mr. Johnson. City staff, please.
No report.
Thank you. City attorney.
I have nothing to report, ma'am.
We'd like to thank you for your time. You'll be with us for a couple of months, I understand.
Yes, ma'am, possibly longer,
I see.
but it's my pleasure.
Thank you, and we appreciate your time. Members. Member Richardson.
Yes, I just want to point out that I'm hoarse. The city of DeLand is now changing their ordinances and simplifying their codes for the downtown district to even to the point of the limitation of what square footage a house can be in order to encourage encourage affordable housing in the downtown area and infill of vacant properties. And I think we should take a look at that. I'll be following that in the next few months. It's a case of simplifying the regulations for housing in the downtown community. I just wanted to make sure that the members of P&Z knew about that.
Thank you. Member Faison, please.
A few weeks ago, I rode over to, I can't think of the name of that town, good Lord, over near Orlando. Nonetheless, they had a nice bubbling frontage area of businesses and folks going down to the water and enjoying that. Member Perez's wife had sent me a nice video of what she had seen about what's going on over at Parish Park. And I just happened to be there today. I lost my drone in the water, but that's not here nor there. It's pretty important because I was looking for my drone in the water. And believe it or not, 3 feet down, I could see the bottom of the floor, which is a few months ago, years ago, you couldn't see that. So our lagoon is getting cleaner, slowly, but it is definitely getting cleaner. And so I just want to just commend the city and make you guys aware. If you guys haven't been down to the river to look at the water, I encourage you to do so. No, it's not crystal clear, but it is definitely getting cleaner than what it has been years past. And so I just wanted to make that report to you guys for that.
Thank you. Ms. Gilbert, we welcome you again and appreciate your participation. I adjourn the meeting of I was going to say Procter and Gamble. I don't know anything about Procter and Gamble. So you'll get a sample size of Tide, another of Gain, and some Comet Cleanser when you leave. Okay. Procter Planning and Zoning for May 18th, 2022. Thank you so much.
You're going to be a YouTube star.